We all know the story. A greedy customer goes through a McDonald's drive-thru, balances a cup of scalding coffee between her legs while driving, spills it, and hits the lawsuit jackpot for millions of dollars. It became a staple of 1990s pop culture. Late-night hosts mocked her, sitcoms like Seinfeld parodied the event, and news anchors used the case as the definitive example of a legal system gone mad. But almost every single detail of that universally accepted story is a complete fabrication. The public didn't arrive at the frivolous lawsuit narrative by accident. Corporate interests carefully crafted this myth to obscure the physical reality of what actually happened. Stella Liebeck was a 79-year-old conservative woman who had never sued anyone in her life. On February 27, 1992, she wasn't driving. She was a passenger in her grandson's parked 1989 Ford Probe, a car that didn't have cup holders. When she pulled the far side of the lid toward her, it popped off. The entire cup of coffee soaked into her cotton sweatpants, which absorbed the liquid and held it directly against her skin. The coffee was so hot, it caused third-degree burns in seconds. The liquid penetrated through her skin down to the subcutaneous fat and muscle across 6% of her body. Concluding that she was clumsy ignores the 8 days she spent in the hospital undergoing painful skin grafts, or the 2 years of medical treatment that followed. Stella initially only asked McDonald's for roughly $20,000, enough to cover her medical bills and her daughter's lost wages while providing care. McDonald's refused. Instead, they offered her a single counteroffer of $800. This refusal pushed the case toward a trial, allowing Stella's legal team to examine McDonald's official corporate operations manual.
Franchisees were required to hold coffee at 180 to 190 degrees Fahrenheit, while home coffee makers hold liquid between 135 and 150 degrees. At 190 degrees, liquids cause third-degree burns in under 3 seconds, leaving customers almost no time to react before permanent injury. Internal documents showed that McDonald's was aware of the danger. Between 1982 and 1992, they had received over 700 reports of people burned by their coffee, many involving similar scalding injuries. Despite these hundreds of incidents, the company had already paid out over $500,000 in prior settlements to resolve burn claims. Yet, a McDonald's quality assurance manager testified that 700 burned humans were statistically insignificant when compared to the billions of cups sold annually. The jury found this indifference reckless. They determined McDonald's was 80. That figure was based on a specific calculation. It represented exactly 2 days of McDonald's global coffee revenue. After the trial, the judge reduced the punitive award to $480,000, and the parties eventually settled for an undisclosed smaller amount. These legal adjustments were largely ignored by the press. The media omitted the 700 prior complaints and the severity of the burns, focusing instead on the idea of a clumsy driver getting rich. This narrative became the face of the tort reform movement, a campaign to pass laws that cap the amount of money victims can win from negligent companies. By turning Stella Lieback into a cartoonish villain, corporate interests were able to lobby for the removal of the very legal protections the jury had used to hold McDonald's accountable. Looking at modern litigation shows how much the landscape for consumer protection has changed since the 1990s. In the recent case of She v. Starbucks, a woman suffered second-degree burns from hot tea that lacked a protective cardboard sleeve. Her case was dismissed based on the doctrine of proximate cause. The court ruled that the missing sleeve was too legally disconnected from the actual spill to hold Starbucks liable for the injury. Today, businesses are often insulated from liability for the same types of injuries Stella Lieback suffered. The cultural perception of frivolous lawsuits continues to influence how these cases are treated by the courts. Stella Lieback was permanently disfigured and spent her final years in a media-fueled humiliation. The next time a ridiculous lawsuit makes the news, we have to ask who is actually writing the punchline.